Iniziamo questo nostro incontro.
Good morning. We can now start this very important event devoted to the topic of human rights. And let me start at the outset with a historical note. In one of the very first editions of the Rimini meeting, one of the topics had been peace and human rights. So I think there is here a kind of a continuity that leads us to the event of today. We will be dealing with two outstanding guests this very important topic. Which is obviously topical today more than ever, has to do with our coexistence. Now, this topic has very often been dealt with at the Rimini meeting, thanks to contributions of very important lawyers such as Weiler, Marianne Glendon, Robert George, Carter Sneed. And today we have the pleasure, honor and privilege of having here with us David Kretzmer, who has a very long experience in this field. Now, from 1995 to 2002, he has been a member of the Human Rights Committee at the UN within the International Convention for Civil and Political Rights. And currently he is working as a professor of international law at the Jewish University in Jerusalem. As I said, an expert of constitutional law, human rights, and international law in general. Marta Cartabia, you all know her. She has been here before. Professor of constitutional law at the University of Milano, Bicocca, and together with he is back together with David Kretzmer after a period of 1 year in New York. I mean, some of the most outstanding scholars and professors got together for 1 year, and they attempted to make a leap forward in their reflection upon a topic which has to do with all of us. I think the perspective that will be used today is to some extent imbalanced, as with a focus on the role of the institutions. We'll be dealing we'll have to find out who are the institutional actors that are supposed to decide on some important aspects, important for our coexistence in terms of human rights. Now, who and why has the authority to take decisions, to take ultimate decisions on some pivotal issues that have to do with human rights? So the floor is now to Professor Marta Cartabia, who will deliver the first speech. Thank you very much, Professor Di Martino, and thank you very much to the organizers of the Rimini meeting for having invited me again to deliver a speech here and hopefully also a discussion and draw your attention to some very important issues connected with human rights. I mean, we've been dealing with it for the past few years, and there is obviously an ongoing discussion on this topic. So the topic, or rather the question that we are raising this year, has to do with the institutions that are connected with human rights. Now, who is supposed to take decisions? Whose task is it to take decision on crucial issues related to human rights? In particular, why is there a growing role of international organizations to the detriment of national institutions? very often international decisions are imposed upon national institutions. And also we could ask ourselves, why is it that more and more judges or bureaucracies or technocratic institutions have started to deal with controversial topics, such as these one, which are emotionally and politically loaded as all the topics that have to do with human rights. Now, being this the issue, being this the topic or the question, we've been dealing with it together with my colleague Mr. Kretzmer. Also, we do it professionally and politically to some extent. But, I mean, we will start for our reflection taking into account two facts which are to some extent similar but also different. And I would like to start firstly by what is going on in Europe, what is at stake in Europe, in particular, starting from a few controversial examples that have been either already decided upon or still pending at the European Court for Human Rights. I don't want to actually dwell upon them or go into the detail, but rather to understand the role of this international institution. How has it changed? And then after my presentation, a colleague, Professor Kretzmer, will be focusing upon the role of the institutions of the United Nations under that umbrella. And obviously, he will use his long-standing experience as president of the Committee for Human Rights of the United Nations. Now, let me mention a few cases of last year or of the recent years. Now, 2010, we see a growing number of controversy, of conflicting issues that are more and more important for the destiny of our human coexistence. And these cases are dealt with in the tribunal in Strasbourg. Now, first case, without going into any details, has to do with the problem of artificial fertilization. So there has been a ruling on an Austrian case. A decision was taken in the spring of 2010. And if you look at the Austrian legislation is very similar to the German legislation and the Italian legislation. And with reference to artificial fertilization, the point of reference is the following. Fertilization is authorized as long as it takes place within an official couple. So we're dealing here with a homologous fertilization. On the contrary, it is forbidden in the case of a heterologous fertilization. That is to say, the one implying an external donor or a rented mother, etc. Now, for different reasons, Austria, Germany and Italy have reckoned that it was a good idea to limit or to ban heterologous fertilization. Different reasons that have to do, in some cases, with the prevention of the marketing of human reproduction in general, the sale of semen, the sale of embryos, and other cells, or to guarantee the identity of the future baby. Maybe if you don't know for sure who's the mother or who is the father, obviously there are very serious legal implications that the law intends to avoid by forbidding it. Now, in Italy, we know that this type of reasoning has been at the center of the very lively debate which had been going on in Italy, both on the political scene and in the media on the same topic. I'm referring to the debate on artificial fertilization, a highly controversial issue in Italy. I mean, the chambers of the Italian parliament had to intervene with new legislation, but also directly the Italian people. You all remember that on this topic a referendum had been held in Italy. Now, the European Court of Strasbourg, in a very recent decision taken by simply by one chamber, so we're dealing with less than 10 judges, well, they consider that the Austrian legislation on this specific point was against the human rights. And therefore they considered it in violation of the European Convention for two main reasons. Firstly, a piece of legislation distinguishing between homologous and heterologous fertilization inevitably, and this according to the court, leads to a discrimination between different type of couples which are hit by fertilization. So violation of the principle of non-discrimination, firstly, and secondly, and closely intertwined with this problem, is the fact that if you restrict access to artificial fertilization, would be equal to a violation to the right of a private and family life. And this is one of the fundamental rights, and it belongs, and to this topic in general, it also belongs to your right to have a child. Now, I don't want to pass any judgment. I want to go into details. Let's go back to the initial question that I had raised. Now, why on earth, for what reason, are the judges in Strasbourg authorized to decide that Austria, and mind you, I mean, we're talking about Austria, but for many reasons it will soon be applicable to all the countries that have a similar legislation. So, in all likelihood, also Italy and Germany. And these countries will have to amend their legislation, making it more flexible, more permissive, and removing these limitations to heterologous fertilizations, while the political debate and also the Federal Constitutional Court in Germany had considered these limitations as lawful. Of course it is a limitation to a right, but we all know at the same time that these rights are never absolute. If you look at the written text at all constitutions, or including the convention, all the rights have intrinsic limitations, and this to safeguard and protect interests that are not merely individual. So why on earth the Strasbourg court can they prevail over the Austrian, German, or even Italian parliament, or over the German Constitutional Court? Why are they stronger? Now, cases similar to this one, either still pending or already decided upon, just to give you another hint, similar cases have to do with the problem of marriage. Again, a very controversial issue in many Western countries. Assisted suicide, euthanasia, etc. Headscarf for the girls that want to go to state-run schools, etc. These are other examples that have things in common. So why are these decisions more and more taken in international institutions? More and more these decisions are taken in Strasbourg rather than in Rome, London, Paris, etc. I would like to draw your attention to the fact that the institutions that take these decisions are actually institutions made up very often of a tiny group of people, of judges. I mean, the court in Strasbourg, it has a total of 47 members, one for each of the 47 member countries, and they end up taking decisions that are valid for millions and millions of people. So it's a severe disproportion. As you know, we have millions of inhabitants in Europe, and only 47 people have this huge responsibility, really a formidable responsibility, and a daunting task indeed. There is then another case that I would like to dwell upon before going on with our reflection on the role of this institution, and it is a role which has been, it's a case which has been very close to the Italian people and will be the object of a very important discussion this Friday afternoon with, we will hear Professor Weiler and others. I'm talking about the Lauzi case, and the relative respective decision of last November concerning the exposure of the crucifix in the Italian classrooms. Obviously, you have all read about it in the Italian papers and media, and it is widely known that the second chamber of the European Court, so an even smaller number of judges, so not 47, but maybe fewer than 10 judges, well, they blamed Italy because for allowing the display, the exposure of the crucifix in the state-run classrooms. The Italian government did not simply passively accept this decision imposed upon them, also because they have to do with the very negative reaction on the part of the public opinion and other national groups. So they have requested an appeal, and the case is far from being definitively closed. The final decision, the final ruling, is expected for this fall. Now, there have been many reactions, not only on the part of Italy, but also on the part of different groups of the civil societies, many NGOs that sided with Italy, with the Italian government, in support of this move of the Italian government to challenge this ruling, and also up to 8 governments of the Council of Europe, so governments which do not have a direct interest in this decision, decided to side with Italy to request that this decision of removing crucifixes from the Italian classrooms be reconsidered on the part of the European Court. Now, the panel that will discuss here on Friday, they will have time to go into concepts such as secularisms or freedom of religion, etc., things that are connected with the decision in Strasbourg. But we have to ask ourselves, why is it that a decision of this kind ended up in Strasbourg? Is there any, is it warranted? Now, in this case, maybe even more that the case on assisted fertilization is extremely interesting, because if you consider relationship between public institutions and religions, then in the different European countries there are different traditions, long-standing traditions, rooted in history, with very diverse traditions, very different backgrounds. Europe is multifaceted in this respect. There are countries in Europe that have gone for a total secularism of the state, such as France and Turkey, the secular approach, lay approach. And then there are countries, many more than those that you could think of in Europe, that have a religious, a confessional state. Greece, Malta, all the monarchies of Northern Europe, Scandinavian, and including the UK. There are then countries such as Italy and Spain that have formal relations, confessions that have formal relations with the state, or on the basis of a specific agreement, pact, or concordat, like the Catholic Church in Italy, with the Italian state. Now, why is this important? Because if at the national level, then the responses to these problems, relations between the religious level and the public level, if the responses are so different, then to transfer the decision from the national level to the international level implies a very significant change, a far-reaching change. And it's an attempt to standardize, to end up with a standardizing attempt which would be applied throughout in Europe. I mean, if we have to end up with one single answer as to what relations have to be between religious and public institutions compatible with fundamental rights, then the diversity of traditions, diversity of the history of the various countries, then we lose that all of this huge heritage could be lost. The court in Strasbourg got to their ruling, first-degree ruling on the crucifixes in classrooms as incompatible with the Convention on the basis of two principles. First, freedom of religions for all of us, and secondly, also on the basis of the educational pluralism, the right for the parents to educate their children as they best reckon. Now, as I said, I don't want to challenge principles, and I think we can all agree on the fact that the principle that freedom of religion is a fundamental right, a huge value that we have to safeguard with all possible means, especially in the current situation, including its aspect of freedom from religion. I mean, you can deliberately decide not to believe in anything. Maybe some members of the audience will remember a famous interview given by Don Giussani, which had been published with the title Lay, Therefore Christian. And in that interview, Don Giussani, in replying to a question on the confessional state, Don Giussani replied, no, it is not a confessional state that we are aspiring to, because, I mean, even if the freedom of one single person to think differently, then we have to safeguard and respect that freedom. So, as I said, no challenge on the principles. Freedom of religion in our multicultural society requires a new approach. This is absolutely true, but it's a principle. What I feel we can all challenge is what lies behind the decision of Strasbourg. That is to say, the fact that it is one only way to decide upon freedom of religion, and that this only way corresponds, more or less, with the secular French model. Now, why on earth should the French paradigm wipe out, again, thanks to the voice of this international institution, wipe out the pluralism, the many different responses that the different states have got to and have been building over the years? I mean, I think the examples that I have quoted, assisted fertilization, freedom of religion, and all the other cases that I have briefly mentioned, are only the tip of the iceberg. These are some of the most controversial issues to which many more could be added. I think there is a dangerous trend that has started over the past few years, this attempt of too strong a role of the European institution, and especially the European tribunals and courts, with reference to human rights issues. So, and here we get to the center of our question. So why is it like this? Where are the risks? Where are the benefits of this method? What are the possible explanations of this general trend? And as usual, with questions of this type, there are different explanations that can be put forward. If you allow me, I would like to dwell on three possible explanations for this relentless growth of the international courts with anything that is connected with human rights. Now, one possible explanation could be to take into account the hyperactive attitude of judges, tribunals. They want to be protagonists. I mean, we all know that judges usually have a very strong desire to be in the limelight. Obviously, this is a temptation in general for any judicial institutions, for any tribunal, and this is particularly true when the political counterpart are weak. Whenever we are in the presence of weak political institutions, then it's easy to see in any country, in any Western democracy, I mean, and not only in Europe, it's easy to get to the judiciary taking the function of substitute. I mean, the judiciary power, judges, legal experts tend to perceive themselves, they take on this, Mary and Glendon mentioned this romantic role of going beyond their limits, going beyond their institutional limits. So the judiciary becoming the substitute, a replacement for the absence of the politicians, an inactive or dormant politicians. This explanation could be taken into account with reference to the crucifix issue, because, I mean, although the debate on crucifixes in Italian classroom has been going on for a long time in Italy, it is also true that on this specific point, political institutions have never come up with a clear response, a clear answer. And it is indeed true that it has never been clarified whether those very old pieces of regulations of the 20s and 30s which established that crucifixes had to be exposed, whether those pieces of legislation are still valid, are still binding, or can be neglected. I mean, if you go and look and read those old pieces of legislation, it's very interesting to see that they are not clear. I mean, those pieces of legislation, about 100 years old, included long lists of classroom furniture and furnishings. So you can find in those lists the teacher's desks, the pupil's desk, the ink pot, the blackboard, and the crucifix as one of the many things that can be present in a classroom. I mean, that was current in the 1920s, 1930s, very old pieces of legislation prior to the Italian Constitution, in a context which was completely different from the context of today. But nevertheless, on this specific point, neither the Italian Parliament nor the Italian Constitution, they have never come up with a definitive position, unfortunately. There have been many interventions on the part of judicial organs, the tribunal in L'Aquila, the tribunal of the Region Veneto, the Consiglio di Stato. There have been institutions that have said something on the issue, but never a definitive decision. So I think we can say that on this specific issue, there is no clear position of the Italian people and its respective representatives, a clear position, and this is obviously the part of the explanation of why international institutions have had to step in and provide us with an answer, because there was no proper or adequate answer at the national level. But for the other case that I mentioned, the problem of assisted fertilization, well, in Austria, Germany, and to some extent also Italy, although Italy had not been directly involved in this legal action, well, in those countries, positions had been taken, decisions had been taken. So this first explanation cannot be used again for the second case. It can be helpful for certain cases where politicians or the Italian will has not been clearly indicated, but for other cases it is not a proper explanation. And this leads us to find different explanation on this growing and stronger role of international institutions. So a second possible explanation that we can resort to explain these events has to do with the the growing role and the growing presence of a culture of individual rights, which has pervaded the West, at least after the end of the Cold War. So historically, I mean, this is a consideration that any scholar, any expert of human rights, on which all of them agree. So after the fall of the Berlin Wall in the 90s, and especially for the Western democracies, since the 90s there's been a flourishing, so all the activities connected with human rights and involving very often international institutions. And since then, every new political or social problem, every new problem tends to be perceived and to fall within the framework of individual rights. It ends up being entangled in the problem of human rights. If you think of all the legislation on the environment, very often you end up with a reply implying the individual rights, or the issues that have to do with bioethical issues, end-of-life care, etc., the right of death, the rights of future generations, the rights of the children, etc. These topics all end up being closely intertwined with the problem of individual rights. This is usually the key that is used to come to solutions for these problems. This implies a huge burden, a huge amount of work for the international institutions. I mean, the more we fuel this culture of individual rights, the more we will have cases ending up in Strasbourg or the committee or other institutions of the United Nations. Think about the numbers. I mean, the European Court, under the official figures that you can all look at in the internet site, in 2009, the European Court is dealing with 120,000 pending cases, roughly. It's a huge number if you think. It's really too much. But it becomes even more impressive if you think that there are only 47 judges at the court in Strasbourg, although they are broken down in different groups, but they have to deal with a huge burden of work. And the ability of the court to come up with decision is the capacity is only 2,000 cases of years, but the number of cases is constantly growing. Now, you will obviously understand that even if you take into account that many cases are very simple, are not eligible, or are groundless, etc., I mean, in spite of this, nevertheless, the court will soon be on the brink of collapse, or maybe already collapsed, I don't know, and unable to face up to so many cases, to this avalanche of cases. Or, if not breaking down, the response will be extremely delayed, and you can very well imagine something that has to do with human rights cannot possibly wait for 10 years to have a decision. I mean, delay implies injustice. Whenever justice provides you with a delayed answers, inevitably there is injustice. There is or either injustice or no justice. Recently there has been a summit leading to the declaration of Interlaken, and the European Court is aware of this risk, is aware of the problem of this avalanche of requests. They have attempted to come up with a solution, but the replies provided are absolutely inadequate. I mean, they are attempting to reorganize the services internally, but I mean, these measures are absolutely unable to solve the problem at its roots. I think on my behalf that instruments and tools are present, but they would require a great effort on the part of the court to self-limit what they are doing. So unless the court in Strasbourg will decide to take on again the subsidiary role that is for that court and leave the justice mainly in the states instead of international institutions, and unless the court will leave a margin of maneuver to international institutions, leaving most of the decision in the states and limiting its interpretation only to some specific cases, then I think that it will not be easy to overcome this very serious institutional problem that we are currently in. And then there is a third possible explanation, if you allow me, that I would like to dwell upon a few more minutes. And it's a very deep, far-reaching explanation that goes beyond this relentless growth of the role of international institutions connected with human rights. And I think this explanation has to do with an ambiguity, has to do with a difficulty in understanding the meaning and the task of these institutions. The European Court, exactly like any other international institutions connected with human rights, was created as a response to the consequences of the Second World War and the Holocaust. I mean, the horrors of those years had fueled distrust. The distrust towards the national states and their respective policies. I mean, national states had fallen prey to totalitarian approaches, both right-wing and left-wing. Therefore, this very urgent need led to the birth of external institutions that had been meant to safeguard human beings, people, against any possible degeneration of the state or totalitarian derapage in the European states. I think that so the idea was to remedy the injustice and the terrible examples of injustice that had been experienced in those terrible years. In other words, human rights and the respective institutions have their roots in that need for justice, in that deeply felt need for justice, which is in the heart of all of us and which is ever present whenever injustice is perceived or perpetrated, no matter how serious, no matter whether individually or collectively. So there is a very deep and noble ideal which lies at the foundation of the human rights. It is this aspiration to justice which is important in the life of all of us. So if the states and the respective political institutions very often tend to be where conflicting, and so unlike the states, institutions are there to serve the ideal of justice, the ideals of human rights, and this is also the reasons why they are legitimate, why they are authoritative, why they are credible. It's a very noble and high aspirations that leads to justice and that justifies the presence of international institutions. This is why, possibly one of the explanations why their role has been constantly growing. But at the same time, there is a paradox in this human attempt toward towards justice. And if you think of the wisdom of the ancient people, something that is constantly forgotten, summus ius summa injuria. I mean, whenever justice goes beyond certain limits, there will be injustice. And even if you read Voltaire, we find something very similar to this. un droit porté trop loin devient une injustice. I mean, whenever justice goes beyond certain limits, it will generate injustice. Or, I could quote something else, fiat justitia et pereat mundus. Or I could also quote Amartya Sen in his latest book on justice. I mean, if the world perishes, there's nothing to be happy about. This is why it's the most known images connected to justice ever since ancient times has to do with the scales of justice. And the two scales have to be brought back to balance. So the human desire, the human attempt for justice, either it is balanced or it is not. I mean, the experience of the recent centuries teaches us that the aspiration for justice is always exposed to the risk of degeneration, of utopian degeneration, especially if it goes beyond the limitations of the human condition, just like the Ulysses, Dante's Ulysses. And there is a very nice exhibition, by the way, on this at the Rimini meeting. Ulysses who goes beyond the Pillars of Hercules, but unfortunately with a very unsafe boat. Now, the love for justice runs the risk of becoming a hubris unless it doesn't take into account the limitations of the human condition. It becomes power, or a method of power and overpower of men upon men. So these institutions that were meant to protect men against the generations of powers could in turn become instruments of power of men on other men. I mean, this risk is ever present. So in the name of human rights, we are running the risk of promoting interests only of the happy few, only of groups that are more influent than others. Although apparently everything is done in the name of human rights. And mind you, I'm not thinking of cases that which are very distant from our world. A lot more on this will be told in the event on Friday afternoon. So in the cases of Lao Tzu, I mean, this risk is really very present. Professor Joseph Weiler, talking in front of the court in Strasbourg, you all know that he's a Jew, and he defended the presence, the exposure of the crucifix in classrooms. Joseph Weiler stressed the fact that in the present historical situation, the main divisions are not between persons that are members of different religions. And you all know what happened in this room yesterday afternoon. But rather between between lay people and religions. The Europe of present day is going through this very dangerous division and clash. And in this framework, promoting lay institutions that is not equal to promoting neutrality. I want to draw your attention to this. It implies taking a position. It implies siding with one of the two visions that are facing each other in the debate. I mean, an empty white wall in a classroom within the specific historical and cultural framework is not equal to have to being impartial and to a very balanced position. An empty and white wall speaks volume, on the contrary. It is the same as admitting that the public culture is a godless culture. Therefore, the dilemma that we are in, and whose solution is far from being easy, and so the European Court in Strasbourg, they had to decide on the crucifix in Italy, but they didn't have to decide between the Christian Catholic approach and the neutral approach, insisting on the removal of the crucifix from the classrooms. It is rather a dilemma between two positions that are equally committed and equally difficult with reference to the religious aspect. Now, how can we find space and room to get to a genuine freedom on this? Now, I think you have all realized that the topic of human rights in general can lead to various interpretations. Although it is motivated by this desire for justice, it is nevertheless constantly exposed to the risk of becoming instrument in the hands of one side against the other. Don Giussani, in his religious sense, explains this in a very figurative way. I mean, without the perspective of something else, justice is impossible. And then he goes on to say that if there is not something more, the human nature that prevails, then the metamorphosis has already started. Philosophy becomes ideology, and the violence or acts of violence on the part of power can very easily occur. I mean, if we neglect that the ideal of justice is always inextricably present and will never be exhausted, or outreached, then this project will never be accomplished. This is again Don Giussani. This is why in a recent book, the Nobel Prize Amartya Sen suggests that we have to correct our relationship with justice. He criticized Rose, which formed the conscience and the majority of the liberal thoughts in Western Europe. Amartya Sen says that the human aspiration for justice should be the engine, the driving force in view of correcting all the acts of injustice instead of aspiring to a model of perfect justice. To remedy injustice is not the same as fulfilling or accomplishing justice, and history is there to demonstrate that all the various approaches of justice that do not take into account these limitations of the human nature inevitably end up generating even worse types of injustice. Going back to other problem of human rights, I mean, what are the implications for us and for the role of the institutions that are there to safeguard human rights? Well, I think that this awareness should be used, rather than to restructure or reorganize the institutions, should be there to recall lawyers and judges, those who work in this institution, to the importance of human rights. I mean, human rights have always said and will always have a very important role in our coexistence and in our notion of democracy. But their role is a limited role. Human rights will never be able to meet all the requests, all the demands for justice of humanity. And I think on this we have to be very careful, insist on our awareness, be aware of what is going on. I think this awareness requires on our part the need of a modest and balanced approach to human rights, so that they are brought back to their initial raison d'etre, that is to say, to correct injustice, remedy injustice, taking into account also the structural disproportion between the human capacities and the infinite and huge need for justice that lies in the heart of each and every one of us. Thank you very much.
Cedo immediatamente la parola a...
I leave the floor to David Kretzmer.
Thank you very much. First of all, I would like to thank... Is it working? It's working? Yeah. Okay. I'd like to thank Professor Martino for his very kind introduction. And especially, I would like to thank the organizers of this very important Rimini meeting for inviting me to participate. I'm especially pleased to share the podium today with my friend and colleague, Professor Marta Cartabia, especially seeing that, as you will notice during my talk, we have some disagreements on certain of the issues which she spoke about. Perhaps not disagreements, but some different perspectives. I also want to apologize to this audience that I cannot speak in Italian. I had to choose between Hebrew and English, and I thought there are probably more people in the audience who would understand the English than the Hebrew, so I will be speaking in English. Like my colleague, I want to start off by mentioning four individual cases which seemingly are very different, but which raise similar problems. I'm going to be talking about dwarves, same-sex marriage, Holocaust denial, and headscarves. And you can try to guess what the connection is between them. Let's start with the first case. Manuel is a dwarf. As such, he found it very difficult to find employment which would allow him to make a decent living. Eventually, he found a special kind of employment. Wearing suitable protective gear, he would allow himself to be thrown short distances into the air by clients of a discotheque, and he would land on a soft bed. Many people found this highly offensive. They thought it was a violation of Manuel's human dignity that he was treated in this way. The authorities in France, where Manuel lived, were persuaded, and the local mayor promulgated a regulation forbidding the practice of what became known as dwarf tossing. The authorities argued that they were protecting Manuel's right not to be subjected to degrading treatment, and that the practice itself was a violation of public order. There was one problem. Manuel himself did not agree. He did not think that his dignity was being violated. On the contrary, by depriving him of the only job he had managed to find, he claimed that the prohibition itself violated his human dignity. He appealed to the courts in France. He was successful at the first level, but the government appealed, and at the highest level, he lost the case. The court held that dwarf tossing was an affront to human dignity and that it could be prohibited even if it affected the right of the individual to employment. Now, what was Manuel to do in this kind of situation? He had nowhere to turn. He couldn't turn to any other court in France. He decided to bring his case before the Human Rights Committee, a body of 18 experts that monitors compliance of states with the International Covenant on Civil and Political Rights. Manuel claimed that he was discriminated against. There were many other forms of work that were maybe regarded as degrading by others, but they were not outlawed. The so-called oldest profession in the world is just one example. Now let me go to a second case, very different. Juliet and Jennifer are a lesbian couple who live in New Zealand. They wanted to get married. They approached the marriage registrar, but he refused to register them on the grounds that in New Zealand, marriage means marriage between a man and a woman and a man. They appealed to the courts, but the court said, sorry, that's the law in New Zealand. So they too turned to the Human Rights Committee. their argument being that they were being discriminated against on grounds of sexual orientation. The third case is entirely different. It involves a man called Robert Faurisson. He's a French Holocaust denier. He claims that the gas chambers are a myth and that the Nazis never had a plan to annihilate the Jews. In 1990, the French Parliament passed the so-called Gnoseology Act, which amends the law of the freedom of the press in France and states now that it is an offense to contest the existence of the categories of crimes against humanity as defined in the London Charter of August 1945, on the basis of which the Nazi leaders were tried and convicted by the Nuremberg Tribunal. After this law was enacted, Faurisson gave another interview to the press in which once more he denied the Holocaust crimes and intimated that the Jews had made up the notion of crimes in order to serve their political interests. He was arrested, he was tried, and he was convicted and fined by the French courts. He too complained to the Human Rights Committee. He complained that his freedom of research and his freedom of speech had been violated by his country, France. Now let me deal with the fourth question. A young woman called Rahon is a young Muslim woman who lives in Uzbekistan. She was studying in the Islamic Affairs Department of the Tashkent State Institute of Eastern Languages. She believes that her religion demands that she wear the hijab. The university authorities did not like this one little bit. So the rector issued a regulation that forbade students from wearing religious dress. When Rahon refused to comply, she was excluded from the classes. She applied to the courts in Uzbekistan, but her petitions were rejected. She too brought a complaint before the Human Rights Committee, arguing that the regulation violated her right to freedom of religion. Now, these four cases are all very, very different, but they raise two common questions, one of which is exactly the question that Professor Cartabia addressed. The first question is what I would term the substantive dilemma. We have in each of these cases a clash of values. There is a dilemma and we have a choice that has to be made between the conflicting values. In the case of Manuel the Dwarf, there's a clash between the outside perspective of what human dignity demands and the internal perspective of the actual perceived victim himself of what human dignity requires. Manuel wants to work and earn a living, and he is prevented from doing so. He cannot understand why he's being singled out. Why isn't prostitution being banned too? Juliet and Jennifer have a strong case that they are being discriminated against on grounds of their sexual preference. Why can men get married to women, but not women to women and men to men? But they are up against strong traditional values and deeply held perceptions on the concept of marriage and family, which are obviously often influenced by sincerely held religious views, whether those are religious views of Christians, of Muslims, or of Jews. Faurisson demands to know how it is that a state can lay down historical dogma and criminalize persons who challenge it. If one state can prohibit challenging the existence of gas chambers, cannot another state prohibit challenging the view that its citizens never collaborated with the Nazis? Doesn't freedom of speech imply even the right to be wrong? But then what about the sensitivities and the emotions of Holocaust survivors, or families of persons who were murdered in the gas chambers? After having been through all that they went through, must they now have to hear that they made it all up, that it was all a myth? Rahon sincerely believes she must wear the hijab. She wants to study. and she wants to do so without violating her religious duties as she perceives them. But can't the state say that we want to keep our educational institutions neutral and that religious dress defeats this purpose? Can't the state say that we want to maintain equality between men and women and the hijab symbolizes male domination? So here we have the clash of values. And the second question, and the more important question, which is actually the subject which we are addressing here today and which my colleague Professor Cartabia addressed so eloquently, is, well, who is going to decide in these cases which values prevail? In each of these cases, some institution has to decide. But why should the final arbiter be an international body like the Human Rights Committee? Why can't we leave the matter for the decision of the political and possibly judicial institutions of the states involved? And we could say, well, who are these so-called experts of the Human Rights Committee who are being called upon to decide these cases? What special qualities do they have to decide the issues after they have been decided by the political and legal institutions in the states involved themselves? I'm going to start off with the second question, the institutional question. And let me first say something about the nature of the Human Rights Committee. The European Court of Human Rights in Strasbourg is well known in Europe and is certainly among this audience. And we've just heard an eloquent address by my colleague questioning two decisions of the court, especially the decision of the court claiming that it was a violation of the Convention for Italy to display the crucifix in Italian schools. The Human Rights Committee is much less known than the European Court. It was established under the International Covenant for Civil and Political Rights, which, together with the International Covenant on Economic, Social and Cultural Rights, is the mainstay of international human rights on the universal as opposed to the regional level. These covenants were the first major steps taken after World War II to give legal standing to the rights enshrined in the Universal Declaration of Human Rights, adopted by the UN General Assembly in December 1948. Professor Cartabia has spoken about the rationale for these conventions, and I think it's worth repeating. The rationale behind the human rights conventions, both universal and regional, is that the state, no state, can have unlimited power to decide what rights its citizens and residents will or will not have. Every human being has certain fundamental rights merely by virtue of his or her humanity. And these basic rights are not a function of the political regime in which the people live. The International Human Rights Conventions were developed as a reaction to the most horrific crimes known in history, to a situation in which a state had organized a campaign to commit genocide, to annihilate a whole people. Today, 165 countries are parties to the International Covenant on Civil and Political Rights, and 2/3 of these countries have accepted the individual complaints mechanism, which allowed people like Manuel and Juliet and Rehan and Forreston to bring their complaints before the committee. Unlike the European Convention, that applied at least originally before the expansion of Europe to include the former Eastern Bloc countries, the European Convention originally at least applied to countries with fairly similar traditions and political culture. The Covenant applies to countries with vastly different political, social, economic and religious traditions and cultures. Some of these countries are democratic. Many of them are not. Some of them have secular regimes. Others have constitutions which give special standing to religion and religious law. Some are rich, others are very poor. The states which drew up the international covenant were not prepared to establish a court like the European Court, which would have the competence to make binding decisions. Instead, they decided on a committee, the Human Rights Committee. It is made up by 18 individuals. These individuals are nominated by their own countries and elected by the states which are parties to the covenant. However, once they have been elected, they do not serve as representatives of their countries, but as independent experts. Many of the members, especially from the Western countries, are either professors of law like myself or active or retired judges. They are generally very independent-minded and do not toe the line of their respective governments. The committee has actually two functions. It considers the reports of states on the measures they have taken to comply with their obligations under the covenant, and it expresses its views on individual complaints such as the 4 complaints which I mentioned at the outset. It is true that the committee's views in these complaints, unlike the decisions of the European Court, are not legally binding, but states are expected to respect those views. Otherwise, of course, there's little point to the whole project. However, the fact that the committee's views are not binding means that the committee has to tread rather carefully. Its views will only be regarded as legitimate by the countries which are party to the international covenant if it does not overstep the boundaries of norms that are generally acceptable in the vast majority of states which are parties to the covenant. It should be able to persuade the states and other interested parties that its views are the proper interpretation of the provisions of the covenant. Now, let me go back to my cases and see how the committee decided them. In the case of Manuel the Dwarf, the committee actually respected the decision made by the French courts. For various reasons, it restricted the issue to one of discrimination. It accepted that the ban actually only applied to dwarves, but because only dwarves are tossed, however, it stated, and I'm quoting, the ban did not constitute an abusive measure, but was necessary in order to protect public order, which brings into play considerations of human dignity that are compatible with the objects of the covenant. The committee accordingly concludes that the differentiation between the author and the persons to whom the ban applied was based on objective and reasonable grounds. The fact that there are other occupations which could be banned on the same grounds but were not banned did not, in the committee's eyes, invalidate the specific ban on dwarf tossing. The same-sex case presented the committee with a tremendous dilemma. As I noted, there are 165 states which are party to the covenant. In many of these states, consensual relations between adults of the same sex are still criminalized. Homosexuality is a taboo that is either denied or suppressed. The committee could not lay down a law that would only apply to New Zealand. If it decided that New Zealand was bound to allow same-sex marriage, it would be saying that every state party, the 165 states, were bound to do so. This would have clearly lacked legitimacy and would have undermined the committee's authority in the eyes of a large number of states. So it won't surprise this audience that the committee dismissed the petition. It justified its decision, of course, by latching onto a provision in the covenant which says that the right of men and women of marriageable age to marry and found a family shall be recognized. The committee interpreted this to mean that a state was only obligated to recognize marriage between men and women. In June of this year, the European Court of Human Rights reached the same conclusion on the basis of an identical provision in the European Convention. One can draw one conclusion from this case, which I'll mention before I go on. And I think it is a very, very important conclusion for anybody who looks at the Human Rights Committee. That body cannot serve as a body whose task is to impose the most, I would call him, if you excuse me, the most avant-garde ideas accepted in liberal Western societies as human rights norms, which have to be imposed on every country of the world. And the same-sex marriage case is clearly an example of that. What about the Holocaust denial case? Well, the French law itself seemed overbroad, and many members of the committee thought that the law itself was not compatible with the right to freedom of expression. But they were not looking at the law, they were looking at the specific facts of the case. And the covenant demands that states prohibit incitement to racial hatred and discrimination. The committee held that this law could be regarded as necessary in order to protect the right of the Jewish community in France to be free from incitement to hatred, and therefore it did not interfere in the decision of the French courts. So here we have three cases which pose serious issues, dilemmas in a clash of rights, in which the committee showed deference to the states. The fourth case of the headscarf was different. As you probably well know, the European Court of Human Rights has also dealt with headscarves in educational institutions, both in Turkey and in France. The court has upheld the ban on wearing headscarves in educational institutions. But in each of these cases, the state involved persuaded the court that there were strong grounds of public order to justify the restriction on human freedom. In the case before the Human Rights Committee, the state failed to provide any evidence whatsoever of the public order grounds which could justify placing a ban on the wearing of a headscarf in a university. And the committee therefore held, contrary to the existing jurisprudence of the European Court, but specifically on the facts of the case, that by disallowing the use of headscarves, the state had violated the right of Rahon to manifest her religion. Now, deciding that there has not been a violation is not typical in the decisions of the Human Rights Committees in individual complaints. On the contrary, when one looks at the statistics, in the majority of cases decided by the committee, it finds one or two violations by the state involved. But very few of these cases actually involve a clash of values of the type that was involved in the cases that I mentioned. There are cases which involve unfair trials, torture, or cruel, inhuman, or degrading treatment in prisons, killings by state agents that are seldom adequately invested, and other severe human rights obligations. Now I come to the question which Professor Cartabia addressed. Why should the committee be the body which decides the cases that I described? Why shouldn't there have remained issues for each state to decide? None of the cases that I mentioned were cases in which the lives of persons or their fundamental personal liberty were at stake. They are a far cry from the crimes of the Holocaust and of World War II that provided the impetus for human rights law. It seems to me that the answer is connected to the notion of the indivisibility of human rights. The human rights conventions, such as the International Covenant on Civil and Political Rights, are what may be described as a package deal. Together with the provisions protecting the right to life and the right to be free from torture and arbitrary arrest There are the rights to privacy, to freedom of expression, and of course the right to be free from discrimination. The meaning of these latter rights, and especially the question when it is legitimate to place restrictions on the liberty so as to protect the rights of others or other social values, are indeterminate. There is no technical, mathematical answer that we can give to these questions. It involves a value judgment. This means that inevitably the institutions which are entrusted to enforce the rights, whether it be the European Court of Human Rights or the Human Rights Committee, have no choice but to interpret the provisions of the conventions. And as I said, this is not a technical task. It involves deciding, for example, whether the provisions stating that the right of men and women of marriageable age to marry and found a family shall be recognized rarely means only men and women getting married to each other. Clearly, both the Human Rights Committee and the European Court of Human Rights could have decided otherwise in this case. The interpretation they chose was dictated largely, if not solely, by their perception of what could be regarded as exception and acceptable. I could say the same thing about the case of the crucifix in Italian schools. I can certainly understand the sensitivities of large portions of the public in Italy to this deeply held culture, Italian culture, far above the religious symbol involved. But then somebody had to make the decision, yes, but what about the child who goes to school and who does not want to sit in a classroom where he or she is exposed daily to a crucifix which doesn't represent his or her religion? What if that child feels intimidated by that? What if that child says, a classroom, which is a classroom in a multicultural and multi-religious society, must provide me with neutral grounds where I don't feel by entering the class that inevitably I am somewhat different and that I don't belong to the culture. Somebody had to decide this case. Professor Cartabia thinks it should have been left in the hands of the Italian courts. But as I said, two answers I'm going to give to this very important argument that she raises. Number one, and I've already mentioned that, the human rights conventions are a package deal. They mean that the kind of human rights issues that come before international bodies depend to a large extent on the nature of the regime and the political, economic and social conditions in the relevant state. Professor Cartabia mentioned that there are 120,000 cases pending before the European Court of Human Rights, but a huge proportion of those cases are from Russia, and they relate to issues in Chechnya, or they are from Turkey and they relate to military action by Turkey against the Kurds, or they relate to questions of fair trial in courts of former countries of the former Soviet Union. Now, the impetus for the international protection of human rights grew out of the realization that we cannot allow states to do the most horrific things and then try to justify them on the basis of the argument that these are internal domestic matters and that other states and the international community have no right to interfere. But that protection cannot be restricted only to the types of cases coming out of Russia and out of Turkey, or the kind of cases before the Human Rights Committee coming out of Jamaica or coming out of the Congo or coming out of some countries with horrific human rights records. All states have to come on board. And when all states come on board, all states have to pay a certain price. Now, there is a great difference between international courts and internal courts. They both have their weaknesses, but they also have their strengths. Let me talk about internal national courts. Unfortunately, and a lot of my work has been done on examining the workings of internal domestic courts, especially the courts of my own country, Israel, but also that of other countries. And what we see is that domestic courts are generally oversensitive to what is perceived at the time as the political realities of the given society. They are not always prepared to stand up for individual rights which are threatened by a very dominant majority, especially in times of crisis. On the other hand, international courts, and Professor Cartabia gave good examples, sometimes seem totally insensitive to the political, cultural, and religious realities of the given societies. They cannot be too sensitive because you have judges which cannot know what happens in every single one of the societies which they have to deal with. The European Court dealing with 47 countries, and in each case there's only one judge from the state involved. The Human Rights Committee, 18 people dealing with, in the individual complaints, 105 countries, and only 18 members coming from very few of the states involved. But they sometimes have one great advantage, and that advantage is that they can take a step back. They can look at the issue as an issue of principle. They can look at an issue in a way which is divorced from the emotional background to the issue, which sometimes plays a dominant role in the internal domestic political institutions and even in the internal courts themselves. Now, what does this mean? Well, it does mean that if we now look at international human rights, we see it has come a long way since adoption of the Universal Declaration of Human Rights in 1948. The original philosophy was that all human beings, no matter what their race, religion or sex, have certain fundamental rights, that all states must respect and ensure those rights, and international institutions are needed to make sure that they do so. I claim that this philosophy is as valid today in the year 2010 as it was in the years 1948 to 1966 when the covenants were adopted. True, and we have to admit it, there are always dangers in allowing international bodies to make decisions that relate to the internal matters within vastly different societies. Sometimes they are going to get things wrong. Courts often get things wrong. Sometimes they are going to deny protection where it is needed or extend protection where it is not needed. Many of their decisions are going to be controversial in the states involved. At times, and this I agree entirely with Professor Cartabia, and we've both discussed it at length, one has a feeling that among the judges or the members of these institutions, a certain necessary degree of modesty might be lacking. And I think that modesty is required not only in religion but among legal institutions. But these are all a part of the price that we have to pay for a system which rests on sound foundations. If we want Russia and Turkey to accept the jurisdiction of the European Convention of Human Rights, we have to accept that Italy will do so as well and might have to bite its lip when the European Court decides in a way which many Italians do not like. If in the Human Rights Committee we want the countries in Asia and in Africa and some of the countries with the worst human rights records to be on board. Yes, the Western European countries and New Zealand and France have to be on board itself. Theirs. The question then we really have to ask is, well, would it be better to go back to the old world and to leave all these cases to be decided by internal domestic institutions? Could we really depend on states, not only now, but tomorrow, and the day after tomorrow, and the day after tomorrow, to protect the lives and the human rights of all individuals in their territory and subject to the jurisdiction? The system has its faults, but for the moment, on the international level at least, it's probably the best we are going to get, and we should make the best of it. Now, I want to conclude with some remarks about the theme of this conference. And I'm very touched and moved to have been included in this important event. Human rights are a political, a legal, and a philosophical idea. They deal first and foremost with political power, the political power of the state. And their notion is to place restrictions on the way that power is used, and in recent years, of course, also to place positive obligations on those who hold political power. Human rights do not deal with the heart, but they try to contain the acts of those who are heartless. They lay the foundation for a society in which people can freely pursue the great things of their hearts. They can pursue the things that their hearts desire. It is almost always important to realize, and this human rights persons must have a certain sense of modesty. Human rights are not a panacea for all society's problems, nor does the protection of human rights guarantee that we've solved all the societal problems or the existential problems of the human being. For those who believe, as I'm quite sure most in this illustrious audience do, that faith and religion and the right to manifest and to display one's religion are the way to personal fulfillment and happiness and redemption, it is always best to recall that for religion to play its part, we need freedom of religion. And only human rights is capable of guaranteeing that. The heart pushes us to desire many great things. It cannot provide us with the great things. Unlike the heart, we may be pushed to desire great things in different directions. But we want to aim to create a society in which every person can have the freedom and opportunity to follow the desires of his and her heart. And it was that message that I end. I bless you all, and I bless human rights. It is our hope for the future of mankind. Thank you very much.
Ci siamo resi conto che il tema affrontato.
Now, we have all realized that this topic is indeed crucial and extremely complex. It would be of no use to simplify it or to pretend that there are no differences, that there are different reasons, that there are different explanations, that there are clashes. within this topic. Therefore, as a conclusion, I would like to draw your attention to three simple facts, two simple things. Also to underline the most significant things, positively and negatively, of the two speeches, both the similarities and the differences. Now, first, human rights are not the panacea for all the problems of the human coexistence. This was said by Professor Kretzmer in the different societies, different situations. Well, I think on this we could reflect. I think human rights, fundamental rights, universal rights, depending on the classifications. Well, the very language we use implies a subject with rights, man with his rights, human rights. But if we switch the elements, man with rights, the man of rights, we will end up in a situation where the risks of human rights being a panacea materializes. I mean, who is man? Who can tell us who is man? Maybe for some reason we have an imbalanced situation, as correctly pointed out by Professor Cartabia. She's underlined three different reasons of why we have relinquished this decision. Who is man? I mean, the response nowadays, it lies in the rights, the long list of rights that we have at our disposal. Now, please, let's reflect on a relationship between anthropology and right, the idea of man and right. It's a circle. It's a circular relationship. So right implies a certain conception, certain notion of man, but at the same time influences it and promotes a specific notion of man. I think the situation we are in does not emphasize this dimension, unfortunately. In the long list of rights, there is also, behind it, there is a specific conception, notion of man, and I mean by no means to condemn the right. I think we should all be very careful. The list of rights entails a specific philosophy. That's why I think we have to pursue the debate. It's either standardizing effort in terms of human rights. I think human rights have always been very significant. They represent progress. They play a very positive function. But I think we have to be careful at all times, to be critical, because every time we have standardized universal definitions, a definition like this runs always the risk of becoming the exact contrary of what it was meant for. I mean, standardizing, universalizing rights is that specific vision that is supposed to prevail over all the others' visions. I don't mean to say in any way that rights have no value, but I think we have to be critical, wary, on who can correct the correct. I mean, those who put remedy, who are they monitored by? Human rights, they are used to remedy. Then we have to be vigilant on those who do this job. Second observation, the prevalence of the solutions that are imposed upon us from above. There are good reasons for this, clearly pointed out in the two speeches. But there is a danger behind this. Institutional utopian. So the dream of systems that are so perfect, whereby men, the effort done by men to be good is pointless. The risk that freedom can disappear. Obviously this is an exaggeration of a risk which is connected to the relationship which has to be there between institutions and other forms of power. Institutions guaranteeing rights and also international rights, when we're dealing with with human rights, the rights against crimes against humanity, these institutions that are there to guarantee our rights are always on the point of becoming something else. This is a never-ending job. These institutions guaranteeing rights run the risk of becoming instruments of cultural standardization, or they run the risk of imposing things about other states, and they also have a very important surveillance, vigilance function. Especially in the sentence, every human being has rights that cannot be dependent from the national state. And the other sentence, the experts belonging to this international institution should never be allowed to impose avant-garde ideas in a certain state of the Western world. So a balance has to be found in this relationship between institutions and power, and I think this is where the problem lies. Institutions can become instruments of political pressure, of forced orientation, etc., but and also we have to take into account that can be specific interests, either political or economical. So the selection of those experts that will work in this institution is a very delicate one. It's a very difficult one. And there again we have to be vigilant. And then third and last observation. Has to do with the third explanation provided by Marta Cartabia in her attempt to explain the prevalence of these supranational institutions, be they European or universal. We cannot simply accept as a problem decisions that are thrown upon us. We have to underline the difference between justice and right. A fundamental right is not justice, and justice does not equal to right. And the difference between the infiniteness of justice and the finiteness of our rights is something that has to be underlined. The aspiration for justice correctly pointed out by Kretzmer when he commented on the title of this event, this aspiration requires all of us to be critical. We cannot criticize national states, the way persons are treated in the national states. We are called to criticize those institutions whose task it is that of restricting the action of the national states. We have to abolish if we were to abolish the difference between right and justice, then we open the door for the overpower, the violence of an excessive form of power. And now a final comment.
And this final comment has to do with the effect that all attempts can be perfect. And at the end, the following question was asked. So international human rights have gone a long way, but there are always dangers. Modesty is a necessary virtue. We have to pay a price. In a nutshell, we must, in some cases, decide non-conforming decisions because we have to include and take on board many nations which per se would not respect certain human rights. So there has been a long way, as said. Institutions have gone a long way, and they fall in this aspiration for perfection. So every institution has to be subject to criticism and should exercise a criticism also from the inside. And this is where our responsibility starts. And this is the scope within our responsibility has to be exercised. We have to consider the basic experience of every human being within the context of the society in which he or she lives. We have to accept what we define as heart, and these are fundamental requests and demands. But so when rationality sleeps, it produces monsters. So rationality alone can produce monsters. And if human beings are only considered as subjects of rights, this is not sufficient, because the development of rights and social values changes. But in order to guarantee this, an independent entity is needed. And this opens up another question, and the Rimini meeting wants to answer this question based on its history and experience. So the question is, where does this critical entity come from? An entity that is capable to fill the gap between justice and right without renouncing its tasks, without relinquishing a continuous negotiation, without adopting an unrealistic utopia, but fighting on a daily basis without never giving up. Thank you.